morning and welcome back to the lecture series on tribal studies in India, interdisciplinary perspectives and approaches. So, today we are going to look at the constitutional provisions, protective discrimination and welfare of the tribes in India. We will continue with our discussion from our previous lecture. Now, talking about land and forest rights of the tribals, we have to understand some of the provisions in Schedule 5 and Schedule 6. Schedule 5 and Schedule 6 in the Indian Constitution have specific provisions for land protection in scheduled and tribal areas. Under the Schedule 5, Article 244(10), the governor may make the following regulations regarding land in a state which comes under a scheduled area. First of all, there can be a prohibition or restriction of the transfer of land by or among members of the scheduled tribes in such an area. Next, regulating the allotment of land to members of the scheduled tribes in such area. Further, regulating the carrying on of business or conducting of business as money lenders by persons who lend money to members of the scheduled tribes in such an area. Under Schedule 6, Article 244(2) and 275(1), the regional and district councils have the power to make laws with respect to the following: A. Allocation, occupation or utilization of land excluding the reserved forests for purposes such as agriculture, grazing, residential or other non-agricultural activities which benefit the village or town residents. Next, management and oversight of forests except for those classified as reserved forests. Next, usage of canals or water bodies for agricultural purposes. Next, regulation of jhum or shifting cultivation and similar such agricultural practices. Further, formation of village or town councils and defining their authority and responsibilities. Next, governance matters related to village or town administration, including law enforcement, public health and sanitation. Next, appointment procedures and succession rules for chiefs or village headmen. Further, laws that govern the inheritance and property rights. Next, recognition and regulation of social customs and traditions. So, we see that all these land rights are provided under the Section 3 of Forest Rights Act that was formulated in the year 2006. Next, talking about the usage of land, the indigenous communities have the rights related to the occupation and use of land. The scheduled tribes and other traditional forest dwellers have the right to reside on forest land under individual or collective ownership. They are also entitled to cultivate land for their livelihood and sustenance. From here we move to community rights. The traditional forest dwellers can exercise their customary community rights such as nistar. So, nistar is a term that they use which include access to shared resources and communal lands and similar such rights that are recognized during the historical regimes of princely states and the zamindari system. The rights are extended to using water bodies for fishing and accessing seasonal resources for pastoral needs. Indigenous communities also hold tenure rights over their habitat and they are entitled to formalize the pattas or land records that are issued by local or state authorities. The law enables the conversion of forest villages into revenue villages to formalize their administrative status. The communities conserving forests have the legal right to do so. They retain all traditional rights except that of hunting, trapping or harvesting the wildlife parts. Talking about the Joint Forest Management, the Joint Forest Management Program or JFM, which was shaped or which was formulated in the year 1990, was another attempt to create a partnership between the forest departments and the rural users of forest resources in order to regenerate degraded forest land. JFM, or Joint Forest Management, provides the rights to scheduled tribes and other such forest dependent communities to maintain their traditional forest rights, allowing them to use forest resources and contribute to conservation efforts. Talking about the ownership of minor forest produce, the forest dwellers have legal ownership over minor forest produce that they have traditionally collected within as well as outside the tribal villages. This right extends to access to collect, use as well as dispose of such produce. And this right enables the people to gather, use as well as sell resources such as bamboo, honey, medicinal plants, wax, brushwood, leaves and roots. All these natural resources, organic resources of forests can be used by the tribals as sell resources. They can be sold and economy can be made out of that. Coming to the rehabilitation and protection from displacement, we see that the scheduled tribes or traditional forest dwellers displaced illegally before December 13, 2005 are entitled to rehabilitation. They have the right to rehabilitation, including alternate land provisions. These rights are applicable to both individuals as well as the entire communities, with allocations that are determined by the government or Gram Sabha, in other words village council. So, the village council or the government can determine and allocate them these rights and alternate land provisions. The right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act in the year 2013 provides for comprehensive resettlement for the people that are affected by external projects disrupting organic habitat. So, the Land Acquisition Law of 2013, which replaces the Land Acquisition Act 1894, encompasses the scheduled tribes and those that are covered by the Forest Rights Act, and it considers the possibility of involuntary displacement from land and habitat. This law, Land Acquisition Law, expressly provides for acquisition for private companies as well as projects to be executed through public-private partnership. So, Land Acquisition Law was enacted as a way of ensuring fair compensation, rehabilitation as well as transparency in the process of land acquisition. This law is aimed at protecting the rights of the affected communities while also balancing developmental needs. Next, we are going to talk about PESA, Panchayat's extension to scheduled areas. We will look at the different provisions of PESA. Scheduled areas are rich in natural resources and vegetations, and as such they are susceptible to encroachers from the outsiders, the non-tribals, which results in illegal mining as well as forest felling, and they can very well adversely affect the customs and livelihoods of tribal communities and forest dwellers. They can actually disrupt the natural ecosystem, the natural habitat of the local people. To protect the rights, customs and livelihoods of the communities that are residing in scheduled areas, provisions of the Panchayat's extension to the Scheduled Areas Act 1996 or PESA was enacted. So, the provision extended part 9 of the constitution to the scheduled 5 areas. Part 9 of the Indian constitution deals with the panchayats, providing for local self-government at rural level. The panchayats at various levels and the Gram Sabha or village council are endowed with the following rights or following power and authority. A. The authority to prevent land alienation in scheduled areas and take necessary measures to address such issues. B. they have the power to reclaim land that has been unlawfully taken away from members of scheduled tribes. C, they have the rights over the ownership and management of minor forest produce. D, they have the ability or power to enforce prohibition or regulate the sale and consumption of intoxicating substances. E, they have the control over money lending practices that are affecting and that have been historically affecting the scheduled tribes. F, they have the oversight of institutions and functionaries across various social sectors. Next, we see that they have the authority to manage and oversee local development plans, including the tribal subplans and their resources. Next, we see that they have the right to provide prior recommendations for granting licenses or leases for mining minor minerals, as well as approvals for auctioning such resources. Moreover, they also have the right to be consulted on matters of land acquisition, and finally, they have the power to issue utilization of certificates for government works undertaken in the tribal villages. So, with this, we come to the end of our lecture today. Let us meet with a new topic and another round of discussions in our next lecture. Thank you.